right now, a couple hot issues that I see over and over again have to do with advertising items that are on sale. It's an effective and popular technique to say, this is $100 value product, or was 100, or just strike through the $100 figure and then sell it for like $70 or something like that.
Hey everyone, welcome to another episode of Perfectly Mentored. I'm your host, Jason Portnoy. My guest today on this episode is the lawyer, Rob Freund, who specializes in e-commerce and advertising law. I mean, he's going to blow your mind with how much you probably did not know about your business that you're opening yourself up to liabilities on when it comes to advertising. You're not going to want to miss this one. This one was a fascinating conversation. Check it out. Rob, welcome to the show. Thank you so much for being here.
Hey, thanks for having me.
So why don't we just start with this? Why don't we give the listeners a little bit of background into your legal journey and kind of how you became the social media and e-com lawyer that everyone goes to?
Sure. Yeah. So right after law school, I took a job here in LA at a large international law firm called Greenberg Traurig. It's like one of the classic big law type firms. And it's a firm like that is a great place to start your career as an attorney. I think a lot of law students see big law as like the best possible result because it's prestigious. You're working with clients that are household names. The pay is not bad, but probably most importantly, the attorneys there are some of the best that you could possibly learn from. So from a perspective of being trained in how to litigate, I took the litigation route. Basically, the fork in the road is, do you want to do transactional work or do you want to litigate, meaning handling lawsuits? I chose litigation. And yeah, I was able to work with some of the most talented litigators in LA. I was there for about 6.5 years. And a lot of what we did, I mean, a firm of that size does almost everything. But what I focused on was business disputes, particularly class action defense work. And in California, especially, a lot of consumer class actions have to do with advertising laws because we have so many consumer-friendly laws that are amenable to turning into class actions. That California, so many of them are filed all the time. And so what I was doing and our team was doing was helping large companies deal with these issues that came up in the context of advertising. And that area of work, specifically advertising as a subject matter, was just much more interesting to me inherently than some of the other areas I was exposed to. Like I did financial services work for a while. It's interesting for a bit, but it's not the kind of stuff that I would just spend a Saturday morning reading about just because I'm into it. And advertising is that for me professionally. There's the consumer psychology aspect. There's old laws trying to be applied to new ways of selling things. That's interesting. And the dynamic between marketers being innovative and regulators trying to catch up, and what happens to the consumer and all this, that kind of stuff is just much more interesting to me than a lot of other areas of law. Ultimately, like most people, there was a point where I realized that staying long-term at a firm like that is just not going to be for me. One of the reasons is it's really hard to do business development when your hourly rate is like $1,000 an hour. It's really hard to get your foot in the door, especially as a younger attorney, if you don't have, amazing relationships at the top of companies. And when you're in like your early 30s, I don't have that many friends that are that level yet. Your career growth as an attorney sometimes is accelerated beyond the people that you know. So in other words, I didn't know that many CEOs. It's hard to bring in business and so on. And another thing is at a firm of that size, like a lot of times you're working with companies that have robust in-house legal teams anyway. So there's like hundreds of lawyers sometimes. And it's hard to really feel connected with what you're doing if, let's say you win and dismiss a huge class action, you spend a year working on it, maybe you'll get a thank you email. Not that I'm like in it for the thanks, but it's nice to feel a little bit more connected with your clients. So I decided to leave and open my own practice and focus on advertising and e-commerce issues, particularly selling stuff online. And towards the end of my time at the firm, we would have more and more clients come to us before litigation happened to sort of like clear what they were doing. Like a big video game company was about to release a new game. They had all their ads prepared, and we'd look it over, identify the risks, suggest things that should be changed, and so on. And that, to me, is a lot more satisfying than, in a lot of cases, than the actual litigation. Like clients are usually in a better mood when they're not actively being sued. And then when you see the ad run, it's nice to see like, okay, we helped them out and they, was still successful, and that stuff is fun. So I thought if I can just focus on that 100% of the time, that would be my ideal practice. And so that's what I set out to do a couple of years ago. And that's pretty much what I do now, is like 70% sort of compliance consulting to help brands, agencies, influencers, and other creators understand the risks of what they're doing, and not to just say no to everything that has risk, but to let them assess the risk and then make the business decision of how much of it to take on. And yeah, I still litigate probably like a third of the time when issues related to advertising come up. But the focus is in avoiding that situation in the first place.
So this is going to be a fascinating conversation, because there's so much gray, I think, or from a non-legal standpoint. There's so much gray, but let's start here, because we're going to dive deep into a lot of these things. What are the most common mistakes you see e-com companies making that open them up to legal liabilities?
There's a lot to work with there. I think especially for smaller, very early stage businesses, not getting an entity set up in the first place. I know that's such a fundamental thing that probably most listeners to this will have taken care of, but it's worth mentioning because there's so many times where, maybe you've had your hands in a whole bunch of different business projects, or you've teamed up with a friend and now one of them is actually working and getting traction. And maybe you're a year in, but you never took the time to document who's doing what are the responsibilities, what are the obligations. And it's that situation that's just like a breeding ground for some dispute that's costly and distracting down the road, especially when people go into business with their friends. I don't know what the psychological explanation for that is, but the sort of nastiest litigation is when people start out as friends and then there's a business problem. So get your entity set up, have your operating agreements set out as early as possible. And it's basically like sort of insurance in case something goes wrong. You can spend as little time as necessary to deal with something that comes up. But beyond that, in terms of like actually marketing things online, the trends in terms of what claims are attractive to plaintiffs' lawyers sort of shifts over time. But like right now, a couple hot issues that I see over and over again have to do with advertising items that are on sale. It's an effective and popular technique to say, this is $100 value product, or was 100, or just strike through the $100 figure and then sell it for like $70 or something like that. But there's federal and California laws, and other states have it as well, that have pretty specific requirements about when you're allowed to do that. You can't always have things on sale. You have to have sold an item at that former reference price for a certain amount of time before you can mark it down. And it's that kind of, it almost seems like, well, what's the harm there? You're still getting a product that's worth $70 and you paid $70 for it. So what's the issue? But it's not always the case that the way the law is written jives with what you might think of as common sense or what's fair. But there have been, I honestly don't know how many class actions about that law, but the settlements and the judgments that come out of those things are multiple millions of dollars pretty often. And it's because anybody who's seen the ad can join in on that class. So the theoretical liability for that kind of issue is potentially like all of your sales for the last X number of years.
So how do e-commerce companies even stay up to date with the amount of these type of laws? Like I've never even heard of that. Like I know that, most of our clients, they slash the price and put things on sales. I didn't even know that's actually a liability. And I actually had my own e-commerce store, and I didn't even know that. How do the listeners, if they run e-commerce stores, how do they even like just keep up to date with all the laws around this?
Yeah, I mean, there are online resources available. Like the FTC, to their credit, does a pretty good job of having information available online. It's not always in the easiest to digest format, and there's kind of that problem of, well, if I don't know it's an issue, why would I go learning about it? But I mean, this is why my job exists, basically.
Yeah.
So ideally, you have an in-house attorney, or you're working with a lawyer who can look out for these issues for you. Or, at a minimum, you have someone on your team who can do some sort of assessment of the FTC's site of
at what point, right? Like someone just starting their e-commerce store, right? Can't have a lawyer on retainer, or in-house counsel. At what point does this become like, all right, you're doing this amount in sales, you should be having someone on retainer looking at everything?
Yeah, I think I totally understand the difficulty of wanting to hire basically a cost center, or what looks like a cost center, when you're just starting out. My answer though has to be, like, it's never too early to have someone just take a look at what you're doing. You don't necessarily need to have an attorney on like a monthly retainer. It can be something as maybe you're starting out with just one sales funnel and a couple of pages, and you just want to have somebody audit it and look it over and identify the issues. That can be done for not a ton of money, but it can potentially save you from, even if we're not talking about like a consumer class action, there's risk of federal and state agencies taking a look at what you're doing. And even if that doesn't result in a lawsuit on behalf of like the FTC or your state attorney general or something, at that point, you're going to have to hire a lawyer to help you through it. And it's costly and distracting and so on. And that happens pretty frequently. I mean, there are certain triggers that make it more likely. Like if you're racking up Better Business Bureau complaints that you're not responding to, the odds that you're going to get some letter from your state AG increase, tremendously. But to answer your question, it's like that it's worth the expense. And of course, I'm biased saying this because this is my job. It's worth putting a little bit of your budget into, can somebody take a look at what we're doing briefly, or, as much as you want, and at least identify what the issues are. So then you can decide how deeply you want to dig into that and how much you want to actually take on the risk of what you're doing. But yeah, I mean, it would be great if there was some sort of like software that would just scan your site and say, here's where your risks are. But there's not really a good way to do that unless you want to invest a lot of time in self-education, which can be done, or having somebody whose focuses on the area look at it for you.
But is there such thing as even being 100% compliant? Like have you ever met a business that was 100% compliant?
So the answer to that is like, I don't know. I mean, it's possible that businesses are not compliant in areas that are not even my expertise. Like maybe maybe they're not doing rest and meal breaks the way you're supposed to. I don't handle employment law, so I don't really know. And
I meant in your domain, in the advertising and online world domain.
Yeah, I mean, there are. It's an interesting question because there are some businesses that are doing things in a way that I think is safe, but that doesn't necessarily mean that maybe a really creative plaintiff's lawyer would say, well, technically you say this about the product, but a reasonable consumer takes away X. And so we're going to take a run at a false advertising class action about that. There's the sort of like basic stuff where you can be sure you're compliant. Like, is your website accessible to people with disabilities? That's like a really popular category of lawsuit. You can be pretty sure if you've checked that box or not. But the issue with advertising is there's always going to be, or pretty much always going to be, some question as to whether is what we're saying in our ads, could it be interpreted by somebody a court would find reasonable as saying something we didn't intend. That becomes a problem. So it's hard to ever say like you are 100% safe. And the other thing is, like, even if you are, people will still sue you. Like if you're in business long enough, someone is going to try to sue you, even if they're out of their mind.
It's like a badge of honor for a business. No, it's like being audited.
Right. Yeah. It's like, okay, I guess we're at that stage now.
Yeah.
We're big enough to get noticed by somebody who wants to take money from us.
Yeah. So here's a question I get a lot from a lot of e-commerce companies, is they have a picture of a celebrity wearing or using their brand or product, whatever it is. Can they use it for organic and can they use it for paid?
Unless you have permission from that celebrity or whoever their agent is or what have you. The answer to both of those things is no. And the reason is, well, there's a couple of reasons. The primary reason has to do with the right of publicity, which is a different thing from privacy rights. Basically, the right of publicity is everyone has the right to control the commercial use of their name, likeness, and image. You don't have to be a celebrity. Like if you took a screenshot of this and then ran it in an ad, I could theoretically initiate a lawsuit against you under California's publicity rights.
No, you checked off a box when you booked this podcast. I got you.
See, that's the thing. Like I don't even remember. I don't always pay attention to stuff I agreed to. But good. I'm glad that I did that. I'm glad you had me do that. But if someone else, like if I
I got your point.
Yeah. But yeah, in the celebrities case, it's those lawsuits, as you might imagine, are even more costly.
But then you have like things like Us Weekly and the National Enquirer and all that use celebrity images left and right.
Yes. The difference there is they're doing it for editorial purposes and their news reporting. And there's a difference between commercial speech and non-commercial speech in terms of First Amendment protections and so forth. And basically, if they're just reporting on what happened or something like that, then there's not really a publicity rights issue because it's not for a commercial purpose. Whereas if the brand that made this shirt takes this picture of me and puts some dollars behind it, or even just posts it on their brand's Instagram as in their regular feed, then what they're doing is using my image for a commercial purpose. And theoretically, I could state a claim, and especially in California, surprise again, California's the most business unfriendly state.
Yeah.
It's an easy claim to bring. There's mandatory attorney's fees, which is rare. And that makes it so much more attractive for a plaintiff's lawyer to bring. But, there are famous recent examples like Selena Gomez was on the cover of, I think, Vogue like a year ago. And some game company took that image and used it in some game that was on the App Store. And they didn't have her permission. She appears in not very much of the game as far as I understand it, but it's clearly her. She sued. They're asking for $10 million. We'll see what happens. Usually these things settle out and we never really know what the figure is, but it's probably, going to be a significant chunk of change for something that seems kind of innocent. But even if it's not in the celebrity context, I've seen numerous instances where someone is just maybe a micro influencer, and then their image is used on a brand's post, and they have a publicity rights claim if there is not something in writing that granted permission.
So then you and I are at a networking event. You're famous. You're a speaker. You get off stage. We take a picture together. What are my rights with that picture? Can I post that on social media from an organic standpoint? Can I use it? Can I use it as an ad? Like you posed in a picture with me.
You cannot use that in an ad. If you were using it just on your personal Instagram, disconnected from any brand or any commercial purpose, then you're probably okay. But yeah, if you're going to run that in an ad, then you run into the same publicity rights issue.
So I guess you made it clear the rules for anyone, whether you're a celebrity or not, and it doesn't really matter how the photo came about. Even if someone was caught drinking, your juice in Us Weekly, you still can't use their image. But Correct. Now, what about from a user generated content perspective, right? That's the big thing for e-commerce brands. That's the number one type of ad that does well is UGC content. If they tag you in their posts, right, and you're tagged, what's your right to the tagged images?
It's a common misconception that gives you any rights. It really doesn't. There's legally no difference between someone who takes a picture with your product and tags you versus that picture just existing out on the internet. And what you would need, again, is it doesn't have to be like a treatise, but some release of, thanks for tagging us. We'd really like to use this picture for these purposes. Is that okay? It can be that brief. Ideally you want like a one-page thing that is a little bit more than that, but at least something where we have a written communication where this person has agreed that, okay, we can take this picture. Here's how we're going to use it, on what platforms and so on. And you need that kind of release in order to then use that picture on your brand's page or in an ad or anything commercial like that, even though they've tagged you in it. And that is something that has been litigated a lot. There's also copyright issues with that. In addition to the publicity rights problem, whoever took that photo has the copyright to it. And unless in that release, you're transferring, a license to use it, then you're also encountering that copyrights issue. And the sort of combination of copyrights and publicity rights problems in that situation that you just described comes up over and over again.
So can I go down a rabbit hole with you for a second?
Sure.
I'm wearing X brand shirt, right? And I give my phone to my wife and I say, take a picture of me in this. And she takes a picture of me with my phone, or we could do two cases, my phone and her phone. She sends me the pictures, I post it. So now I'm up there. The brand now asks me for my permission. It's not even mine to give them, is what you're saying, right? Like if my wife took it with her phone, technically she's the photographer, she owns that picture. If it's with my phone and she took the picture, well, I own it, it's my picture. She just did me a favor. But if it's with her phone, they need her permission. So technically she could sue the company.
Yes.
Wow.
Yeah, that's right. You can grant the publicity rights. She can grant the copyright in that situation.
Wow. That's crazy.
Yeah.
What about reviews? What about reviews and testimonials? Like when someone sends in a review, or a testimonial onto the page or something like that. Can you use that?
That raises one of the same issues and then a couple separate ones. So if you're going to take
by the way, every e-commerce business owner is freaking out listening to this podcast, by the way. Like they're all like, we've been doing everything wrong. We're opening up. Like it's crazy.
Yeah. I mean, it's not like everything is on the same spectrum of risk.
Yeah.
But it's still, what I tell clients is it's important to at least understand the rules of the game so then you can understand where the traps are. So, if I said no to everything that carries some risk, then you wouldn't be able to market stuff, broadly speaking.
Agreed.
So once you understand the risk and
you got to know what the rules of the game are in order to play the game.
Exactly. So with reviews, if you're going to take someone's review and you're going to use that in an ad, like you're going to screenshot, an Amazon testimonial or customer review or something like that, or even copy it and put it on your website or on your Instagram page or something like that. If you're identifying the person's full name or you're using a picture of them, then you have that publicity rights issue that we just went over. One of the other issues with using reviews and testimonials has to do with principles of truth in advertising generally. So what I mean is the FTC says that all ads have to be truthful, they have to be not misleading, and they have to be substantiated. So if you're going to say something about a product, it has to be true. It can't be couched in a way that's literally true but misleading. And you need evidence to back up whatever you're saying at the time you say it. If you take a customer review or testimonial and use it in your own advertising, the customer's claim becomes the brand claim. So what they say also has to be true and not misleading and substantiated. So for example, if you are in the business of selling like weight loss tea or something, and you're using a customer testimonial that says, I lost 10 pounds in a week. If you don't have the science to say most people can expect to lose 10 pounds in a week, then you have a problem using that review unless you provide the kind of
is that why we see the disclaimer, like results not typical or something like that?
Yeah. And that's actually not enough
Oh, wow.
There's specific guidance out there about results not typical is no longer okay. That changed a few years ago. And now what you need to disclose what the typical result is if you have a kind of performance type claim. Same thing with like money making claims. If you're saying, here's a business opportunity, you can quit your 9 to 5 and make 6 figures a year. If that's not what the typical user can expect to make, then you have to tell people what it is, what the typical result is. So one of the pitfalls in using reviews is thinking that it counts as evidence on its own when that's not really the case. So you have to watch out for what your customers are actually saying, and then think, okay, if I were just designing an ad to put, on Facebook, would I be able to say those same things?
So what about podcasts? I know we kind of covered this a little bit because I said you did check a box, but we're filming this right now. Do I need your consent to repurpose this podcast? Or even run ads?
You probably would, yeah. And once you mentioned it, it jogged my memory that I did agree to. I think I recall thinking like, okay, he's got this covered. But yeah, I mean, there's a sort of joint authorship copyright issue here. We're both creating this work. If you were to monetize it, then you might have a copyright problem if I didn't give you that license. And yeah, I mean, if I were to make some endorsement about some product that you had or something like that, there's the same sort of disclosure requirements there and so on. But you want at a minimum a release of the publicity rights issue we talked about here if you're going to put money behind this or promote it elsewhere. And you want to cover
so is radio completely different for the same reason that like Us Weekly and all those magazines are different in the sense that it's editorial and news?
Yeah, I mean, it depends on how they're using whatever the content is. I haven't been on, is that true? Yeah, I don't think I've been on a live radio program, but it would be the same if a client came to me.
Because you hear it all the time. Like you're listening to 2 Chainz and they name the station, right? Like you hear that all the time.
Yeah, I mean, with that sort of thing, I would assume that artist has had their team look over some kind of agreement with the radio show about like what happens and some, not only like here's the rights releases, but worst case scenarios happen if something goes wrong in the show. What kind of discretion do we have and so on.
Got it.
But generally that's on like the lower risk side of things. If I'm just appearing briefly on a radio show, like how much can you really sell a show that isn't recorded? But ultimately, like any kind of appearance situation like that, you want to think through what content are we creating here? What are the plans for you to use it? What are we going to cover? And, ultimately, like down the road, how am I going to use this content? Is it going to become an ad for something? Am I going to commercialize it in some other context? Am I going to sell it to some other company that wants to use clips of it? Things like that.
So when it comes to working with influencers and you're a brand, what's the best way to approach them in order to get everything that you need?
It sort of depends on the sophistication of the influencer you're working with. And I would leave the issues of what, from a business standpoint, what's the best way to do influencer outreach to the pros I know who focus on that. Like the guys at Kinship just put out an influencer marketing blueprint thing. I'm plugging their course right now just because it came out and I think it's good. But there are people who are very skilled at doing the outreach part. From a legal perspective, you have to have an influencer agreement with every influencer that you work with, no matter the size of the campaign, period. And I know that a lot of people don't like hearing that. And even clients will push back and say, all we're doing is an Instagram story. All we're doing is free product. A contract is going to scare them off and so forth. And having seen issues come up that are more expensive and distracting than people would think for seemingly small campaigns over and over again, my take on that is if an influencer is going to shy away from working with you because you're doing something that's a basic professional threshold, giving them a contract that's maybe more than a page long, then that's not a relationship that's really worth pursuing. In my opinion, like the risk of dealing with what can and often does go wrong in that situation is just not worth it. So I don't know what necessarily the best first step is. Hey, we want to approach this influencer. People have different approaches to that, but at some point before money exchanges hands and before people go creating content, you need to be clear in writing about who's giving up what in exchange for what. And if one side or one party to that campaign doesn't want to sign a contract, then it's not worth it, in my opinion.
Every time I think of influencers and things that go wrong, I think of the Fire Festival.
Yeah, me too.
and I mean, I know that's kind of off topic, but I'm curious to know from your perspective, like what you think of that whole situation. I know it's a bit passé, but I'm just curious from a legal perspective what you thought about that.
It's almost not even passé, because the crux of the issues there from the FTC's perspective still happen, and there's still enforcement actions from the federal government about the issues there, namely people not disclosing that they're affiliated with whatever they're promoting when they make that promotion. So the FTC sent warning letters to like 60 different influencers. I think the number was 60 in connection with Firefest. They're hyping up the show, can't wait to go, whatever, and not saying, oh, by the way, they're paying me to say this. And that's like the classic FTC issue with influencer marketing, not disclosing when there's a connection between an influencer and a brand. And it's not like after Firefest, everyone learned their lesson. I mean, last March, right before COVID hit, there's a company called Teamy that was selling weight loss tea, and they had to pay more than $15 million to the FTC because in their influencer marketing campaigns, the influencers made disclosures. They used like hashtag Teamy partner, but they put them in the wrong place. They put them in a location on the Instagram posts that the FTC said was not clear and conspicuous. And it's like, we're at that level of detail in some cases where, yeah, you disclose it, but you didn't do it in a way that complies with what we want you to do. And now you have this massive enforcement action on your hands. And it's the same issue that was
Who's responsible? Who's responsible at that point? The influencer or the business?
The liability from the FTC standpoint is shared by the brand, the influencer, and any agency that was involved in the campaign. Most of these actions are aimed at the brand and not the individual influencers, but that has happened before. There have been individual influencers who have been...
Well, because the influencer is responsible to put it up there. If they forget to write hashtag ad or sponsored, how is that the brand's, like in the brand's control?
Yeah, so the FTC's response to that would be, it's everyone's responsibility, and what the brand should be doing is monitoring their campaigns and actively checking up on them. They should have in their influencer agreements an acknowledgement that the influencer will abide by the FTC's rules. A best practice is to provide those rules to the influencer in the agreement, like, hey, here's what we're talking about. Here's a link to the FTC's guides. Here's a link to the FTC's Disclosures 101 for Influencers document they came out with a couple of years ago. And by the way, we're going to be monitoring all the posts of this campaign. We have the right to ask you to take it down if we see something's not compliant, and then actually follow up and spot check your campaigns. If you can show the FTC, like, look, we had hundreds of influencers. We can't be everywhere at once. This is an isolated incident, but check out what we have in our agreements. And like, here's what we're trying to do. Then that can go a long way to showing like, look, we're doing the best we can. But brands have been held to account where they don't have that kind of evidence to show, where it's not in their contracts. They can't show they're paying attention. And then what their influencers do get them in trouble, which sort of goes back to one of the reasons why it's so important to have an agreement is ultimately those people are out there making advertising claims as though they're the brand. And so the liability ultimately comes back to you. And similar issues are there with like affiliate marketing. You're ultimately liable for what your affiliates are out there saying about your brand. And that it's that same sort of risk with other people are out there doing things, but it's still your responsibility to monitor it because they're saying it about your company.
This is crazy. I mean, there's like so much here. What about copyright infringement? Like I know we talked about that a little bit, but we see people knocking each other off all the time on social media, memes especially. How does that work? Like it's almost hard to find the creator of a meme. And if you use a GIF, whatever, however you want to pronounce it, although the owner said it's GIF, but whatever the creator said it's GIF, but whatever way you want to say it, like those are created. How do you control how that works? Like there's so much out there that how does copyright infringement work on those things?
Yeah, I'll try to do sort of the basics. I mean, you could spend a very long time getting into copyright, and I can't really claim to be a complete copyright expert, but generally you start from the premise that whenever somebody creates something that has some originality and it's in a fixed tangible medium, meaning, you've drawn it or you've created it on your computer, you recorded it or what have you, you automatically own the copyright to that content at the time it's created. Now, if you want to sue someone for reproducing your work, you have to have registered that work with the US Copyright Office within 3 months of the first date that you published it, meaning, you posted it or what have you. If you're outside of that, then statutory damages are off the table, and effectively it's much, much harder to sue for infringement. So you have the copyright by default, but to be able to enforce it in court effectively, you need to register it with the Copyright Office. So in the context of memes,
most people don't do that.
Almost no one is copyrighting their memes. Some people are. Some people understand the landscape and are thinking there's so much value in when we create these that it's going to be worth it to police the marketplace to the extent you can. And, the whole point of IP rights is to keep credit and ownership over what you've created. But other meme creators just want it to be spread everywhere, and that's not what they're after. Whether or not your use of a meme constitutes copyright infringement is a very tricky question. And a lot of the confusion has to do with the meaning of what fair use is. Fair use is a defense to copyright infringement. So practically what that means is it's not like I get to take a picture and change it a little bit, and then if somebody sues me for copyright infringement, I can just make them go away by saying, oh, it was fair use, I transformed it, or whatever other element of the fair use analysis I'm meeting. You have to, in order to really show fair use, a judge has to make that decision. So it's going to be case by case, in court, expensive, not something you really want to have to go through. So it's risky territory to be in, to bank on fair use carrying the day. So, the extent to which you've taken a meme template and then you've added a different caption, or you've changed the names to make it fit like whatever you're doing, is that transformative enough then to get you into fair use territory? Maybe, some cases I think way heavier on one side or the other, but at the end of the day, if whoever made that initial meme has registered it with the Copyright Office and wants to make that a problem for you, are you going to pay their initial settlement demand of like $5,000? Or are you going to hire a lawyer that will probably cost you more than that to figure this kind of thing out in court? And those kinds of decisions are being made by people every single day. There are copyright trolls out there where the entire business basically is sending out demand letters like that because most people are just going to pay, that $3,000 or whatever. And I realize I strayed off topic a little bit there, but
no.
Hopefully that shows you like how much there is to work with in terms of what can I do with content and what happens if I get it wrong and so on.
I'll wrap up with this. What do you think of what's going on with all the tracking? The tracking going away, the privacy complaints, the iOS updates. What's your take on all that?
It's all so interesting and also frustrating because California, again, is taking it upon themselves to be the leader in the country with privacy legislation. And they rushed out this thing called the CCPA. It's fair to call it a dumpster fire. I think that it's been revised a whole bunch of times. They're always coming out with new regulations. It's expensive and difficult to comply with. And what's interesting to me about the whole space is there's such a push for consumer privacy. And you take surveys of consumers and they think, oh, my privacy is so important. I don't want tracking. But my take on it is the reality is like, if you're going to be served ads anyway, don't you want them to be relevant? Like, why would you not want, why would I not want that? I don't see that there's some societal harm to having cookies track what I'm interested in, so that I'm going to watch an ad for, shirts like this versus, joint medication or something.
Yeah.
So sometimes I wonder where these policies are coming from, who they're intended to actually serve at the end. The incentive structure between Apple and other tech giants like that, what they say publicly, what they're actually after. Ultimately, I think that this, the iOS update that allows people to feed that sort of knee-jerk privacy good, tracking bad impulse, I don't think ultimately is going to be a pro-consumer thing.
I agree.
At the end of the day.
I agree. And I think I love the people who say privacy, yet they own a smartphone, right? Which is always on and tracking whatever it is. And Apple's tracking you. It just took away some, tracking from somewhere else.
Right.
And then the beauty of it is that they then go post their family pictures that they're away on vacation from their house for the next 3 weeks.
Right.
They post their kid in the bathtub, and then they say privacy is important to them.
Yeah, or their entire life is resting in iCloud and their password is password or something like that.
But privacy is super, super important.
Yeah, I mean, privacy is of course important, and we don't want tech giants being compromised and not setting up safeguards and so on.
Fair.
But there's a
I don't know. I don't do anything out of the ordinary. That like if someone wanted to track me and follow me around all day, it's pretty boring for them to do it. So
that's generally how I feel personally. Like I don't care. There's nothing that somebody could take that I really care about other than like financial information.
Exactly.
And even then,
yeah.
But no, in seriousness, like there's important interest to balance. I feel like we haven't developed legislation that fits. Let's protect what's actually important about privacy while not crippling businesses' ability to actually comply with these things.
So in your legal opinion, I kind of always wanted to say, I like saying that in your legal opinion, what do you think the future of online advertising looks like, and the best things for brands to do?
I wish I knew what it would look like. I think it's going to be more and more, whatever the next evolution of influencer marketing is. I think people see the value in having ad. I mean, the classic tension has always been, how do we advertise people without it feeling like an ad? And the dynamic is always marketers develop new effective ways to achieve that, and the regulators don't like it and they have to catch up to it. So influencer marketing is, it's not new anymore, but that's an example of, let's make this more personal. Let's make it feel less like an ad. Whatever the next iteration of,
the modern day product placement.
Exactly. And the more personal and individual feeling an ad can be, I feel like that's where people are always going to go when they can develop some new way to achieve that. So I don't know what that looks like, but whatever it is, brands and marketers will be there first, and then the FTC will come in later at some point.
Rob, thank you so much for doing this. I mean, we could spend another 3 hours on it, so we may just have to bring you back to keep the conversation going. But for the listeners whose minds were just blown, and whether they're thinking about closing down their shop because they're going to be open to every liability possible, but actually for the listeners who want to reach out, they want to learn more about you and or even work with you, how can they find you?
I'm most active on Instagram. It's at Robert Freund Law. I spend a fair amount of time on Clubhouse too. And then other than that, you can email me through my website, robertfreundlaw.com. Kind of active on LinkedIn also. So any of those works.
Awesome, Rob. Thank you so much. Really appreciate you.
Thanks for having me on. This is fun.